All right. I think we have everybody connected, so we'll go on the record now. This is Hamill versus Munson Healthcare Grayling, Crawford County case 2111065. So let's just go through counsel here. Mr. Div, if you can put your appearance on for plaintiff. You're muted, Mr. Div.
Yes, good morning, Your Honor. My apologies. Albert Dibb appearing on behalf of the plaintiffs.
Thank you. Counsel on behalf of EPMG and Dr. Eaton.
Your Honor, James Frisch on behalf of EPMG and Dr. Eden.
Thank you. Counsel on behalf of Munson defendants.
Thank you, Your Honor. David Busker at Henless Bronson on behalf of the Munson defendants.
Thank you. Counsel for Dr. Atchison.
Good morning, Your Honor. Justin Hackela for Dr. Atchison.
Patricia Shabath also for Dr. Atchison, Your Honor.
Okay. Is there going to be one of you that's presenting argument today, or how are you guys going to handle that?
If it's okay with the court, I'll handle one motion and Ms. Shabath will handle the remaining motions. We're not going to overlap at all, so we won't be redundant.
Okay. All right, that's all. I don't mind if you split things up. I just don't want to have multiple counsel arguing the same motion or response. Okay, great. Okay, did I miss anybody? No, I don't think so. Okay, great. So we've got a lot on the docket for today. I did have an opportunity in the interim since our last hearing to go through all the materials that were submitted by the parties. I did receive some supplemental briefings that were submitted. I also had a chance to review those. So I kind of have an order that I'd like to go in. If at any point counsel has an objection to the order that we're proceeding or thinks it'd be better to address things in a different way, I'm certainly open to that. But essentially, we're going to start with the EPMG motion, move into the Atchison motions, and then go from there. And then we'll see how things come out. So, as I indicated, the first motion I'd like to address is EPMG's and Dr. Eaton's motion to strike Jessica Nelson. It's kind of a motion to strike, motion for summary disposition, motion for the alternative of a Dauber hearing. So, Mr. Frisch, if you'd like to proceed with your argument.
Thank you, Your Honor. Excuse me. Dr. Nelson's opinions in this matter are wholly unreliable because the authorities and studies directly contradict her opinions. Starting with her opinion is regarding the standard of care. Her opinion is that a perimortem C-section should still be performed after 5 minutes. And to support this position, she relies on Tintinelli's emergency medicine, Williams obstetrics, both materials she cites as authoritative. However, both of those authorities contradict her opinions. Tintinelli's specifically are Exhibit E, states that a perimortem C-section best prognosis for intact neonatal survival is less than 5 minutes. And they reference 1 through 3. Their references 1 through 3 in support of this refers to article exhibit, which is our Exhibit F, which is entitled Perimortem C-section Delivery, were our assumptions correct? Both of this is also cited by plaintiff. In this study, which Dr. Nelson relies on, they review 38 cases of perimortem C-section. Of these, 34 were intact. Time of delivery after maternal cardiac arrest was available for only 25 of these. 11 were delivered within 5 minutes, 4 within 6 to 10, 2 11 to 15, and 7 more to 15. Of these, this directly, It's important to note that the amount of time elapsed from onset of maternal cardiac arrest until C-section delivery varied widely, ranging from 2 minutes greater than 60 minutes. Only 8 of these cases met the recommendation for a perimortem C-section delivery within 4 to 5 minutes. And this author ends with saying that the review of cases from 1986 to 2004 strongly supports performing a perimortem C-section within 4 minutes of maternal cardiac arrest if resuscitation is ineffective. In this case, Your Honor, more than 37 minutes had elapsed between Ms. Hamill's cardiac arrest and her arrival at the hospital. This study does not indicate at all that Dr. Eden should have then performed a perimortem C-section simply because she arrived at the hospital. Rather, it states if at any time a perimortem C-section was to happen, it needed to be done and it should have been done within that first 4 minutes for the optimum outcome. Moving on to Plaintiff's Exhibit G. I'll pull it up here. Sorry. Which is another article titled Perimortem C-section, which is also referenced in Tintinelli. Indicates that the most important consideration for one of these C-sections is the amount of time that passes from the death of the mother to the delivery of the infant. It's, quote, the single most important prognostic factor. And they reference a table 1, which is a table of data collected from 1900 to 1985. In those 85 years, only 3 infants were delivered post-mortem C-section, perimortem C-section, excuse me, after 21 minutes had elapsed. 2 of those had severe neurological issues. Only 1 was normal. Again, Dr. Nelson's testimony is that the C-section should have been performed regardless of the time, and the baby would have had a 50-50 chance of survival, as would have the mom. Plaintiff also directly references a quote from the article stating the survival rate is 45% of infants born at 26 weeks. However, the title of this paragraph is estimated gestational age. This section is only discussing infant survivability at a certain gestational age. It does not discuss the appropriateness of a perimortem C-section and how it will survive, how it will cause an infant to survive. It simply states that babies born alive at the survival rate of 45% of infants born at 26 weeks gestation and 92% at 28 weeks. Simply put, babies that are premature have a 45 or 92% chance of survival. Does that have anything to do with the perimortem C-section? Moving on to the next study that Dr. Nelson relies on and plaintiff relies on, which is our Exhibit D, Plaintiff's Exhibit F, which is titled Perimortem C-section, Cesarean Delivery and Subsequent Emergency Hysterectomy, the study from the Acute Medicine and Surgery out of Japan, is also misconstrued. In this study, they argue that a majority of the patients survived. However, if you look at Table 1, which they cite as the majority of patients survived, the reason that these case study 2, which is the author's state, was only survived because they used BA ECMO, which is life support. Essentially, the person was placed on a breathing and cardiac machines just before the perimortem C-section was even done. And that is what caused her to survive. That's what caused the baby to survive. The only case, number 6, is one in which the mother arrested at home. In this, ECMO was not successful. Resuscitation was not successful. No one knows what happened. The mother died in the emergency room, and the outcome of the baby is unknown. This is the only one that is even closely related to the facts at hand. Again, her opinions are just simply unreliable. Plaintiff's own experts, Dr. Cardwell and Dr. Dhanraj, Dhanraj, contradict her opinions. Dr. Cardwell expressly states the baby was dead when they arrived at the hospital. Dr. Plaintiff's other expert said that he would have relied on the emergency medicine physician to determine if resuscitations were futile and to follow his lead. If resuscitations were futile, he would not have performed a C-section. I might be paraphrasing that. I'm sure plaintiff will correct me if I am. I apologize if I did. And again, neither one could refer to any literature that says a perimortem C-section should be done at any time over 30 minutes. They all repeatedly state the rule is 4 to 5 minutes from arrest. In summary, the literature relies on contradicts her opinion that the standard of care required Dr. Eden to perform a perimortem C-section rated after more than 37 minutes from her cardiac arrest. The literature she relies on and as provided as exhibits here are contrary to her opinions, and her opinions are unreliable. Thank you.
All right, thank you, Mr. Deb.
Yes, good morning, Your Honor. I think it's important to take into account that when Cassidy Hamill arrived at the emergency department at Munson, no one at Munson declared them dead on arrival. In fact, just the opposite. They continued for upwards of 10 minutes in an effort, a wrong effort, I might add, but nonetheless, for 10 minutes, they continued to resuscitate Cassidy, and for good reason, because they realized that what had happened was the EMS first responders were on the scene and were attending to Ms. Hamill when she went into her cardiac arrest. This was not an unwitnessed cardiac arrest that occurred in the field where a passerby comes across an individual and notices that they're collapsed. The cardiac arrest occurred in the presence of the trained paramedic and emergency medical technician, and they took, as you've heard before, prompt resuscitative efforts and continued those resuscitative efforts all the way until they reached the hospital emergency room. They did not declare Cassidy Hamill dead at any time along the way as well. So for defendants now to come in and say that there was no chance for survival, I believe is disingenuous, and it goes against the expert testimony in the case, which I might add is not disputed or otherwise contested with any expert testimony by the defense. All we've heard are lawyer arguments, lawyer interpretations of various studies, which were selected by the experts to support their opinion. And as the court knows, in any peer-reviewed, juried study, any reliable study will give you pros and cons of whatever the issue is that's being discussed. So naturally, any study is going to have a contrary viewpoint, but that doesn't mean that the study is unreliable, and that doesn't mean that the expert's testimony is unreliable. Here, Dr. Nelson is a board-certified emergency room physician. She completed an emergency room residency training. She attended Baylor University College of Medicine. She completed a fellowship in emergency medicine. And compare and contrast her credentials and match them against the defendant's, where the defendant is not even eligible to complete an emergency room residency. In fact, the defendant, Eaton, is not an emergency room medicine physician at all, though he's required to and is held to the standards of care of an emergency room physician pursuant to the law. His training is that of a family medicine doctor, of a general practitioner. He's not trained as an emergency room physician, has never completed a residency in emergency room medicine, emergency medicine, and his credentials don't stack up to the credentials of Dr. Nelson. Now, Dr. Nelson carefully looked at the case. She testified that her opinions were based upon her training, education, and experience. She testified that her opinions were based upon her careful and thorough review of the medical records, her review of the depositions in the case, and medical literature that she offered up. Defense did not offer any medical literature to attempt to cross-examine her. And while the medical literature that was used to cross-examine her may be used at trial to cross-examine her, they certainly don't disqualify her opinion, her expert opinion, which, again, I remind the court, stands undisputed in this case by any expert testimony whatsoever. This defendant has not shored up one kernel of expert testimony by the defense to dispute any of Dr. Nelson's opinions. So what does Dr. Nelson say? And this is all borne out by her deposition testimony, which we've cited in our brief. Number one, there should have been a perimortem C-section performed, no matter how much time elapsed. And again, I remind the court that she continued to receive oxygen. She was being well oxygenated. She was receiving chest compressions and CPR all the way from the scene of her collapse to the hospital. It's as if this had happened in the hospital, actually. In addition to not performing a perimortem C-section, which all the literature, the American Heart Association and the article that Dr. Nelson cites, which cites the American Heart Association protocols, all say that a perimortem C-section is the only way in a situation like this, where a pregnant patient has suffered a cardiac arrest. The standard of care is to perform a perimortem C-section. Instead, they continue to try to resuscitate her. Now, they're trying to resuscitate someone who they're claiming was dead on arrival. That is an inconsistency, which is not explained by the defendant or by any expert testimony on behalf of the defendant. The next thing that Dr. Eaton failed to do was properly position Cassidy Hamill when she was brought into the emergency department. He did not position her so that the uterus was displaced and so that IV medication could be effectively administered and circulation restored to save her life. These were two critical mistakes that Dr. Eaton committed, and which Dr. Nelson testified were violations of standard of care. Now, in her deposition, she testified that, and by the way, defendants are asking for a Daubert hearing, and I would submit to the court that defendants have already had their Daubert hearing. They have already cross-examined her on her opinions, and they've already had the opportunity, which they would otherwise have at a so-called Daubert hearing. They've already conducted their Daubert hearing in the deposition. So a Daubert hearing at this juncture, I think, would be superfluous. It would not shed any more light on the issues for the court to decide. Dr. Nelson did testify that had Dr. Eaton complied with standard of care, that there was greater than a 50% chance of survival. And again, nothing to dispute this. Nothing, no expert testimony offered short up by the defendants to dispute Dr. Nelson's opinions, and rather we have, lawyer interpretations of medical studies and articles, which I would submit to the court are not as reliable as an expert's read of those studies. There was some reference made that Dr. Nelson isn't qualified because supposedly she had limited experience in dealing with a patient of this type. And of course, that's not true. She testified at page 180 of her deposition that she commonly diagnoses and treats the OB population in the greater Houston metropolitan area that comes to the ER, and compare and contrast that to Dr. Eaton's experience in dealing with a situation like this, which is none, zero. Dr. Eaton, a family practitioner, has never seen, prior to Cassidy Hamill, has never seen an eclamptic pregnant patient in the emergency department. So to say that Dr. Eaton is competent and qualified to talk about the standard of care, and Dr. Nelson is not, I submit to the court, is disingenuous. But we concede that this situation, a pregnant patient in cardiac arrest, is an extremely rare situation. But as Dr. Nelson explained, when it does happen, the emergency room physician must be prepared to address it, must understand the standards of care in how to care for and treat the patient. And there are two patients to be mindful of. Of course, there's the mother and the baby. And when I say this is a rare situation, I think Dr. Nelson testified that 1 in 30,000 cases does this occur. So whether the baby died, quote unquote, by the time they got to the hospital is a question of fact, which I suggest to the court should be left to the jury to decide as to whether or not the baby was salvageable. And it doesn't negate the obligation to perform the C-section, because even if you presume, which we contest, even if you presume the baby died, the only way to treat mom is by evacuating the uterus, and that is by properly positioning the patient, first of all, and then by performing a perimortem C-section. I don't think that's in dispute at all. That's the only way to care for and treat a pregnant patient who is in cardiac arrest. You must, and the literature supports this. Dr. Nelson testified to this, pages 131 and 148. Dr. Nelson testified to this, that the literature still mandates that you empty the uterus and perform the perimortem C-section, even if it's beyond 5 minutes. Exhibit F is the article that sets forth the American Heart Association standards that the perimortem C-section should be performed. And there was a study, as has been referred to. And again, these studies are going to give you all perspectives, which is what medicine does. It looks at all the perspectives, not just one myopic perspective. But there were 6 cases that were reviewed, and a perimortem C-section was performed during cardiac arrest, and resuscitation was in fact successful in 4 of those 6 cases. And in one case, it was performed 41 minutes, way beyond this 5-minute window of time that the defendants are relying upon. One C-section, perimortem C-section, was performed at 41 minutes. Another one was done at 51 minutes. Another one was done at 44 minutes, and another one was done at 22 minutes. And a doctor testified to this at page 118 and pages 207 to 208, which represents, Your Honor, a 67% opportunity that to survive and to discharge. So there is a question of fact, and I don't believe there's a question of fact that the perimortem C-section should be done beyond 5 minutes. I think that any reasonable expert would tell you the same. Tintinelli's textbook supports Dr. Nelson's opinions, but even in the absence of these articles, the expert testimony, particularly when it's unrefuted, should still carry the day, I think. And the testimony is that in Tintinelli's textbook, for example, viable infants recovered even in the absence of fetal heart tones, and even if more than 5 minutes, the 5-minute mark was exceeded. And at page 491 of the Tintinelli article, it specifically states that perimortem C-section should be performed regardless of fetal viability. So again, failure to perform the perimortem C-section, empty the uterus, wasting time performing the ultrasound. They took time as she was brought in to the emergency room to perform an ultrasound that was inappropriate. They improperly positioned her. They couldn't get the meds in to the patient properly to assist in circulation and to assist in her blood pressure. She was getting CPR and oxygen and had blood flow from the moment she collapsed until the time she got to the hospital. And for these reasons, Your Honor, we would respectfully request, one more thing, Exhibit G also stands for the proposition that out of the 38 perimortem C-sections that were performed, 34 of the infants survived. And then there was another study where 20 perimortem C-sections were performed and 13 mothers were resuscitated and discharged in good condition. So for all these reasons, we would respectfully request that the court deny the motion, deny the request for a Daubert hearing, recognize that there is a question of fact, that a genuine question of fact that has sufficiently been raised by the plaintiff, and deny the motion. Thank you, Your Honor.
Thank you. Mr. Frisch, any response?
Yes, just a couple. A Dauber hearing is for the trial court to determine whether the experts' opinions are reliable. And each case presents unique circumstances for the court to make that determination, not for us to. Dauber hearings are not conducted during a deposition. And secondly, plaintiff made a lot of points about emergency medicine treatment and CPR. So as a former paramedic for 10 years, I had to be very careful not to testify. But I'd like to point out here in the article that patient was discussing with the 67%, all of these are different. The ones that survived, the first one, case one, she arrested in an ambulance on the way to the facility. There's an asystole, and the authors point out that patient, that mother, had a return of spontaneous circulation was observed. That's a key point. Ms. Hamill never had a return of spontaneous circulation in the entire 37 minutes. Number two, she arrested in a clinic, and number two received life support, like I said. 3 and 5 arrested in an operating room. They were already in the hospital. I can't think of a better place to have a cardiac arrest than in an operating room at a hospital. Ms. Hamilton arrested in a hospital. She arrested at home, 37 minutes away from the nearest hospital. We could make points. I could submit something to this effect. I'd just like to clarify, EMS personnel do not declare patients dead. They contact medical control authority, give them the facts. That physician makes a determination. Secondly, Dr. Eden has been an emergency medicine physician since at least 2011 up north. He is obviously a qualified emergency medicine physician. If not, he would not be working as an emergency medicine physician for nearly 14 years, a lot longer than Dr. Nelson. Those are my main points. And again, this article that Dr. Nelson refers to doesn't recommend performing a perimortem C-section at any time. What it recommends is CPR, life support, make a decision for a C-section, perform it, and then stabilize the patient. I think those are all the points I want to make just for the sake of time, Your Honor. If you have any questions, I can answer them.
No, I don't. All of these motions have been well briefed and well supported. And the arguments here today aren't really anything different than what was presented in the briefs. So a couple matters that I think bear noting here. Number one, I think it's important to remember that the court is looking at this from a standpoint of a gatekeeper. In other words, the court isn't the fact finder. It's part of this motion. The court's not determining ultimately whether Dr. Nelson's testimony is going to prove by a preponderance of the evidence that the standard of care was violated in this case. The court's looking at this simply as the gatekeeper under MRE 702. And as we're all aware, that is to determine whether or not some kind of specialized knowledge will assist the trier of fact, and whether or not the testimony that's offered comes from somebody who's qualified to give that testimony. In other words, somebody that is reliable, that the jury can accept their testimony if they choose to, and that the testimony itself is reliable. In other words, that a reasonable juror could rely on it should they choose to in making their decision. But the court's not making any ultimate determinations on that. That's the role of the jury. So I think it's important to remember the standpoint that the court is looking at here and its role as a gatekeeper. Also, to the extent that EPMG and Dr. Eaton are asking the court to dismiss them out based on a C10 standard, of course, the parties have accurately cited that in their briefs, and the court has to view all the evidence in the light most favorable to the non-moving party and conclude that there isn't any genuine issue of material fact on the issue of the standard of care here. So looking at it from that standpoint, a couple other things that I do think bear noting, and Mr. Dibb alluded to this, is that this is an extremely rare instance. And I think ultimately that may be something that hurts the plaintiff in terms of the jury's view of this, but it is an extremely rare occurrence. There isn't a lot of literature on it. I don't think either side would be able to find, an expert who could testify to having dealt with, many patients who presented in this fashion. They just couldn't. I think it's actually interesting that Dr. Nelson actually was involved in a similar situation, even though it was, over 10 years prior to her deposition. But that she was involved in a case that involved a pregnant woman in an auto pedestrian accident. So looking at just simply Dr. Nelson's qualifications, I find that she is qualified, and I refer specifically to Exhibit B, which is actually her first deposition, the first session of her deposition. In the first few pages of that, pages 15 through I think about 29, she discusses her qualifications, and I find that she is qualified to give opinions regarding perimortem, cesarean section, and when it's appropriate, when it's not appropriate. And I think just generally, having read her entire deposition, I think she clearly demonstrated sufficient knowledge of this kind of circumstance, sufficient knowledge of the literature surrounding it, and therefore sufficient knowledge on which to base opinion as to what the standard of care is and whether or not it was violated. So to the extent that her qualifications are being challenged, the court denies that motion. In terms of the reliability of the materials that she relied on, I don't find really, I don't think there's much objection to that part of it. I think everything that she relied on in reaching her opinions in terms of literature is well accepted literature. I don't think any of the studies or reference manuals or books that she referenced or relied on have been in any way determined to be unreliable in and of themselves. So then, how reliable is her opinion? There certainly was in exhibit, I'm referring specifically to exhibits D, E, and F of the defendant's brief. There's a wide range of circumstances where perimortem cesarean sections have been conducted at various time intervals. I think Mr. Frisch pointed out ranges from 2 minutes up to 60 minutes from exhibit F, with varying degrees of success. And I also find that it's a highly factual dependent question here. And I think that came through in Dr. Nelson's testimony. Where did the arrest occur? How long was the arrest going on? What was happening during that period of time between when the plaintiff in this case and the individuals that were referenced in the studies, what was going on during the arrest, how much aid and assistance were they able to get in terms of establishing a normal heartbeat, circulation, breathing, all of those other types of things that all play into those time frames. So there's a great deal of factually dependent information that affects potential outcomes. But what I do think is pretty clear from her testimony and from the literature referenced and provided as exhibits is that very far into a cardiac arrest, it's still appropriate to attempt a perimortem cesarean section. And to the extent that it wasn't attempted in this case, I think there's an argument to be made that it is against the standard of care, and I think that's supported by the literature. So again, looking from simply a standard of a gatekeeper role here, I think there is sufficient evidence to make Dr. Nelson's opinion reliable. I think a reasonable jury could conclude that despite all the other factors mentioned by EPMG and Dr. Eaton in their brief, it is still something that should have been attempted, that doing that would have been supported by the literature and certainly supported by Dr. Nelson's expert testimony. Whether the jury accepts that is a completely different question. And as council's aware, the jury will be instructed that they can accept an expert's opinion, but they don't have to. So, again, under a gatekeeper role, the court finds it is reliable enough that the defendant's motion should be denied. I don't find that a Daubert hearing would be helpful. I don't think that the parties are going to develop any additional testimony or information through a Daubert hearing that would change the court's analysis. I think there's enough that was developed through the deposition. So I agree with Mr. Dibb. You know, I don't think there's any more that a Daubert hearing would reveal to the court that would affect its decision in this case. So I don't think a Daubert hearing would be something that would be necessary. So while the purposes of a Daubert hearing, as Mr. Frisch indicated, is for the court to make the determinations, I don't think there's any more information that could be developed through such a hearing that would assist me more than what has already been developed. So for all those reasons, the court finds that EPMG's and Eaton's motion should be denied. And so, Mr. Frisch, I'll just ask that you prepare an order that reflects that rulings for the reasons stated on the record.
I will. Thank you, Your Honor.
Thank you. The next motion that I would like to address is Defendant Atchison's motion under C8 relating to the damage cap issue. And having read the briefs in that, I mean, it's my view, at least without hearing the arguments of counsel at this point, that it is a premature issue. So at least at the outset here, in terms of our argument, I'd like to just like counsel just to address the issue of whether that's something that the court should decide now, or as Mr. Dibb has argued, that it's something that ultimately should be determined post-verdict in this case. So
Your Honor, if the court's inclined to defer this post-verdict, I would have no objection to that.
No, I know you don't. Based on your brief, I want to make sure that the moving. I want to hear. I guess I'm asking to hear what the moving party is. Their position is on that. So, counsel.
Yeah.
What's your view on that? Just that part, and if like I said, I'm kind of haven't made a complete decision on that. I wanted to hear from you guys. So, what's your thought?
My view is there's a genuine issue, a genuine legal issue at work here, and the parties would benefit from some clarity on that, to the extent that there are settlement negotiations, to the extent that people have to reserve this for insurance, etc. Some clarity on the legal issue would be beneficial to everybody. And my view is deferring it is just the benefit of deferring it is you avoid a negative result if you're on the other side of it. Now, obviously, that's because I think that we're correct, but.
Okay. All right. Thank you, Mr. Dibb. Your response to Mr. Hagela's position on that.
I'm prepared to argue the substantive issue.
No. Just what he's saying in terms of if we did have a ruling on that now, it could be.
I don't know how it would it would make things any different than it would in any other situation where the court decided this post-verdict. But I think we argued that in the alternative in our response that it's a post-verdict issue if the court wanted to punt, but I'm prepared to argue it either way, Your Honor.
Okay. All right. Thank you. So I obviously have had a chance to review the motion, the statute covering it. I've also looked up, just did some research on case law in terms of when courts have decided those types of motions. And Mr. Hagela, I'm not surprised to hear you say what you said, that I did consider that. I can see how having a ruling on that at this stage, so that parties have some kind of understanding of what their ultimate exposure might be, could be helpful in settlement negotiations. So I get that piece of it. I also have to look at, from a court standpoint, courts are very hesitant to make rulings on issues that aren't ripe, that aren't necessarily matters that are before the court, other than the parties have brought it, and they're hesitant to give kind of prospective or advisory type rulings. I think it makes it difficult at trial when the court has made a ruling like that prior to trial, in terms of parties making arguments knowing that their damages are ultimately going to be limited if the court were to decide that. So I think it brings up issues at trial, to the extent this is going to go to trial. And I do think it's premature. First of all, the parties have to decide that they're going to go to trial on this. There has to be a verdict that's in favor of the plaintiff on non-economic damages, and that verdict is going to have to be in an amount above the cap. So there's a lot of things that would need to happen. So while I understand it could be helpful from a negotiation standpoint, I don't know that is something that interest in that is greater than the court's interest in not creating issues at trial, not deciding things that aren't right before it, and not deciding things that, frankly, we don't know whether it would ever be an issue or not. So for those reasons, the court, I'm not denying the motion on its merits. The court is simply going to find that the motion isn't properly before the court at this time, and certainly defendants are well within their rights to bring that motion if and when that matter is an actual issue before the court. So Mr. Hackel, if you could prepare an order that reflects that part of the ruling.
I will do so, Your Honor. Thank you.
Okay, thank you. The next matter that I have to go forward would be Defendant Atchison's motion for summary disposition under C10. So Mr. Hackel, if you wanted to proceed to the extent you had oral argument on that motion today.
Yeah, I get that the court has reviewed everything and probably doesn't want me to be too repetitive, so I'll be as brief as I can. The case against Dr. Atchison is that when this patient arrived at his office for a consultation for proteinuria, she had an elevated blood pressure that was rising. She had an elevated proteinuria that had gone up over the course of pregnancy. She had a cough, she had shortness of breath, she had leg swelling, she had headache, she had heartburn, she had kidney stones. And a lot of that comes out of the review of systems that shows up in the University of Michigan medical records. That's what's alleged by plaintiff. A huge focus of discovery then has been what was plaintiff's condition at that visit, because Dr. Atchison didn't document cough, shortness of breath, leg swelling, headache, heartburn, kidney stones. In fact, he does a specific exam that is tailored for preeclampsia. Preeclampsia is not a diagnosis here that is not considered unknown, rare, surprising. It was something that was specifically evaluated for. And his note documents that she denied shortness of breath. She denied headache. She didn't have pitting edema, etc. So we, in discovery, looked at this issue closely and disclosed the form by which the review of systems is documented. What happens is a medical assistant, in this case, somebody named Rachel Lawson, gives a form to the plaintiff. She fills it out, and then it's entered into the system. The form, which, again, we don't have the written form, we have the form that's given to the plaintiff blank, says, have you ever had these symptoms? And that makes sense because she didn't have kidney stones at the time. She'd had kidney stones in her past. But nevertheless, that's what's alleged by plaintiff. So after we talked to the first person in the room, Dr. Atchison, and he explained that she didn't report shortness of breath, she didn't have these things. We then talked to the other person in the room, Christopher Buck. Christopher Buck is the boyfriend of Cassidy Hamill at the time. He's present at the visit. He's in the room with the doctor. He had, he's a competent guy, and he had a lot of time to observe her because he's in the car with her on the way down from the Houghton area to Brighton, Michigan's clinic. He's in the visit with her, and then he's in the car with her on the way back, at dinner, etc. And he says she was fine. They were joking. She was in a good mood. She didn't report any symptoms. She didn't have any problems until 9 o'clock that night, after dinner, after they get home, after they smoke a cigarette in Cassidy's mother's driveway. She then reports symptoms to him. That's the first time many hours later. So he doesn't say she's got shortness of breath, she's got headache. She reported all that to Dr. Atchison. Turns out she also talked to her father on the drive home. So we asked her father, well, what did she report? Was she in pain? Did she have a headache? Did she say, boy, I'm not feeling well? And he says, no. She was laughing. She was joking. She was in a good mood. She was optimistic. So there is no evidence in the case. There is no foundation for the conclusion that the patient reported a cough, shortness of breath, leg swelling, headache, heartburn, or kidney stones to Dr. Atchison. The evidence establishes that she reported on a form that she had had those at some point in the past, and it was documented within the medical chart. That is unequivocal. There is no contradictory evidence to those facts. So when we take plaintiff's deposition, plaintiff's expert nephrology deposition, Dr. Patel, it's somewhat surprising that his testimony is still based upon the fact that she had all of these findings. His testimony is excludable under Badalamenti because it is based upon a foundation, in this case, of facts that don't exist. He concludes, well, she should have been reported, or excuse me, she should have been referred to the hospital because she has all of the classic symptoms of preeclampsia, and Dr. Atchison just missed it. He just, must have ignored a patient who's got the classic sign, the headache, etc., and just missed it. Well, that's not what Dr. Atchison's note says, and that's not what the facts have established, and we have looked very, very closely for anything that might contradict that. So plaintiff's response then is also interesting because it doesn't say, well, hold on, even if you exclude all these facts, even if you take all of these clinical symptoms out, she still has, this proteinuria. And because the proteinuria is X, it's above a threshold level, she needed Y. That's not what it says. Plaintiff's response denies this claim, and it still says she had every sign and symptom of preeclampsia. And the citation for that, tellingly, is not the testimony of Dr. Atchison. It's not the medical chart. It's not any of these other things. The citation is the complaint. So this is bootstrapped. This is an argument that is created by an argument, a question of fact that is created only by the complaint. It's an allegation. So plaintiff has not established the prima facie case to create a question of fact here. And without a question of fact, the expert can't come in and say, well, based on all these facts, this is my opinion, because there isn't some possibility where the jury could conclude those facts are true. He's got to work within the existing facts, and he's not doing that. Plaintiff also says, well, even if you exclude these clinical symptoms, she's got rising proteinuria, she's got rising blood pressure. And so Dr. Patel concludes that all of this still requires referral to the hospital. The problem there too is she doesn't have rising proteinuria. Her proteinuria had actually come down 10% from nearly 7,000 grams per 24 hours at the beginning. See, I may have said 7,000, from 7 grams, 7,000 milligrams at the beginning of the pregnancy. Her blood pressure was certainly high, but it was lower than it had been. Dr. Patel gives us a threshold of 160 over 105 for severe features of preeclampsia. Well, first of all, that's not what she had. She didn't have a diastolic over 105. She didn't meet that criteria. But second of all, that's not the question. The question is not, had she been diagnosed with this condition, would it have been severe or not? Would the features have been severe or not? The question is, did she have it? Did she require referral to the ER? And his opinion is that based upon these clinical findings, she should have been referred because of that. It's not true. His opinion is excludable because it lacks that foundation. And this is not, unlike a classic Daubert motion. We're not talking about his credentials. I'm not talking about the literature. He's relying on facts that are simply not in evidence. So that's our, obviously there's a lot more to it. Happy to clarify, but that's the argument, Judge.
Okay, thank you. Mr. Deb?
So just to be clear, Your Honor, and my friend, Mr. Hakala, in the motion, Dr. Patel's qualifications were questioned and raised. Is that being abandoned now? Because there's a lot to discuss there.
I mean, this is not, I'm not here to talk about whether or not he's a nephrologist or not. So I don't know what he's referring to in the motion, but this is truly, this is just based upon the facts, Judge.
The motion disputes his qualifications to testify as to the standard of care. Is that argument being withdrawn is all I want to know. Are you stipulating that he's qualified?
Oh, absolutely not. What I'll stipulate to, Your Honor, is that we are not raising that in this motion.
Okay, so I mean, well, what I'm viewing this motion on is whether or not there's factual support for his opinion and whether his opinion is based on the actual facts of the case or something else. So
yes,
I mean, that's what I view the crux of the motion as be.
All right, then I won't spend the time discussing his qualifications and comparing those to the defendant's qualifications, and we'll just address what the court has stated. So thank you. Thank you, Mr. Hakala. Let's keep in mind, Your Honor, that this was a very sick lady that presented to the defendant Atchison. She had been mismanaged throughout the course of this pregnancy by her OBs. She had uncontrolled hypertension. She had uncontrolled proteinuria, and the two of those superimposed on her condition was creating a very severe case of preeclampsia. And contrary to what my friend Mr. Hakala has stated in oral argument and in his motion, it is well documented that she presented with all of this laboratory evidence and complaints on this day. What Mr. Hakala wants the court to do is ignore the University of Michigan staff documentation as to what her problems were and accept the observations of Christopher Buck and Cassidy's father and use that in preference to what the University of Michigan documented. So let's talk about that. Again, Dr. Patel's opinions were based on the evidence in the case, his careful and thorough review of the medical records and the scientific literature. And let's take a look at the picture as documented in the medical record at the University of Michigan. What's documented is that she had severe, perhaps even malignant hypertension, blood pressure when she presented. 167/97 in a pregnant patient is not a good thing. There is documentation in the record that she was having headaches, that she was experiencing epigastric pain, that she had low back pain, that she had leg swelling, cough, and shortness of breath. All of these are hallmark signs and symptoms of preeclampsia, severe preeclampsia. And in addition, her protein was significantly elevated at 4.84. Normal, Your Honor, is 0.3. Her condition, she was acutely ill at this presentation. and had all the evidence of preeclampsia and the complications of preeclampsia, particularly lung fluid in her lungs, which was documented at autopsy. Recall again that she would die hours later. And this defendant had the last opportunity to save her life. But contrary to what the standard of care required, he did not consult a maternal fetal medicine. He did not send her to the hospital. In fact, he didn't even consult her attending OBs at Munson and advised them to hospitalize her and to have her seen by a maternal fetal medicine. She had to be hospitalized, as Dr. Patel testified, and she had to be delivered. And again, these arguments put forth by this defendant are unsupported by any independent medical expert. These are, again, lawyer arguments that have no basis other than an argument fashioned by the defendant without any support by an independent expert. Dr. Patel was also critical of Dr. Atchison for not educating Ms. Hamill with respect to what to look for and if present to get to the hospital, particularly all the problems that she was complaining about: the shortness of breath, the epigastric pain, the headaches, and to get to the hospital. Of course, it would be too late because we said this in our response. Dr. Atchison literally sent Cassidy home to die, and that's what happened. All he had to do was refer her to the University of Michigan, have her transported there, and we wouldn't be here today. The argument about Badalamenti is inapplicable because in Badalamenti, the expert opinions were skeptical and were disparaging of the defendant in that case. That's not the situation here. Dr. Patel relied on hundreds of pages of medical records, relied on his training, education, and experience, the medical literature that was cited in his deposition, and our fact-based and evidence-based medicine opinions. It's not, there are no information gaps or misunderstandings as was present in Badalamenti. So to try to use Badalamenti as the basis for this motion is not advisable. So what did Atchison do? He failed to timely diagnose her superimposed preeclampsia. He failed to take into consideration this severe blood pressure in a pregnant patient. Dr. Patel said that a blood pressure of anything above 160 and a diastolic approaching 100, which was Cassidy in the office, is a hallmark feature of preeclampsia. And he cited the medical literature in support of that. She did have leg swelling, as was documented in the Michigan record. She did have shortness of breath and cough and headaches. But for some reason, this defendant is asking the court to ignore it because these complaints were registered by a medical assistant and not by Dr. Atchison. The point being is that they were registered by someone and they're documented in the medical record. Her protein alone was 6,300 grams, 6,300 grams. Normal protein is less than 300. So that alone should have been a siren, a red flag to the defendant that this was an acutely ill patient. Preeclampsia and its complications, the fluid in the lungs, which again was found at autopsy. Everything that was present at autopsy was present in that visit with Dr. Atchison. And for whatever reasons, because perhaps he was not familiar with caring for a pregnant patient in the condition that Ms. Hamill was in, he did not address these issues. Her hypertension, her nephrotic syndrome, these were conditions, her eclampsia that she had that were present, and for whatever reasons, this defendant ignored. He didn't address the leg swelling. He didn't address her chronic hypertension. And all of this consistent with preeclampsia. And Dr. Patel's diagnosis, based on the objective evidence in the record, was that she had nephrotic proteinuria and needed to be sent to the hospital. Dr. Cardwell, who is a plaintiff's maternal fetal medicine expert, also supported the fact that the condition that she presented with in Atchison's office was clearly indicative of preeclampsia, clearly required her to be hospitalized. She wasn't stable. I feel like I'm repeating myself here, but based on her clinical picture, there's no way that this patient should have been sent home to die. She should have been immediately hospitalized and sent to the University of Michigan, and her doctors contacted and advised, because what happened here was a clear violation of standard of care. And the evidence, the factual development of this case does create a genuine issue of material fact, and I would respectfully request that the court deny the motion for these reasons and those set forth in our brief, Your Honor. Thank you.
Thank you, Mr. Hakala.
I'd just like to address one quick thing, Judge. Plaintiff's counsel lost me a little bit when he said these are just lawyer arguments. He has no expert that supports these things. Well, I want to be clear that there's plenty of expert support for the defense of that case, but I'm not critical of the opinion that you need to refer a patient with proteinuria, hypertension, chest pain, shortness of breath, headache, back pain, kidney stones, swelling, heartburn. That patient needs to be referred. My point is, that's not the patient we were looking at, because the review of systems doesn't mean she has that today. Review of systems means that's something she has had at some point in her life. That's what the form says. That's what the patient checked. And that's what it means when it shows up in the record. I can appreciate some confusion on that if somebody's just looking at the record, because it's not the same as Dr. Atchison's history, which says today she does not have shortness of breath. I can appreciate the confusion, but that's been cleared up. We've looked at the form. Dr. Atchison has testified as to how it works. The medical assistant is also on the witness list and could testify, could have been subpoenaed if somebody wanted to scrutinize it. This is simply not the patient we're looking at. And so the trial that we're now kind of envisioning here is not what does the standard of care require in that circumstance. It's what circumstance were we looking at? So there needs to be more than simply a complaint that alleges, X, Y, and Z to create a question of fact. That's not what we have. And the idea that Badalamenti doesn't apply is also incorrect, because what Badalamenti stands for is the idea that an expert witness can't simply disparage the defendant's powers of observation. That's the quote from Badalamenti. You can't just say, well, had he looked closer, he would have found, something different. Had Dr. Atchison looked closer, he would have found shortness of breath, because look, she did report shortness of breath to her dad on the way home, her boyfriend who was in the room, what if there was some hook there to create this question of fact, we would have it, but we don't. And so it's not enough for him to just say, well, she had shortness of breath, and so the standard of care requires referral to hospital. I am now repeating myself, Judge, so I'm going to stop. Thank you for all your time and attention today.
Okay, all right. I did read through, again, the briefs of the parties. So I'm familiar with the circumstances here. Again, I think it's important to reference the standard that the court's looking at, which is C10 in this case, which is there is no question of material fact and that no reasonable jury could find that the elements been met by the plaintiff. And the court, again, has to view all the evidence in the light most favorable to the non-moving party, the plaintiff in this case. I completely agree with Mr. Hacklaw in terms of his reference of the issue here. I do think the question that's raised in the motion is not whether, if all of those conditions were present, whether a doctor knowing all of those conditions and seeing them present at the time should have referred her to the ER or taken other action. It's whether or not Dr. Atchison should have done that in this circumstance based on the information that he had at the time and was given. So I agree with the framing of the issue. So that is a question here. I mean, is there a question of fact that a jury should determine whether or not, given the information he had or maybe should have obtained, and whether he met the standard of care in what he did for Ms. Hamill at the office at the time when she was there. And at this point, based on the information before the court, and certainly, you know, all of these issues are matters that the defense can raise as part of a motion for directed verdict, depending on how things come out at trial. But based on the information that's been presented, the court, I cannot say that there is no question of fact based on Dr. Patel's testimony, based on all the records that were submitted, and looking at it from the perspective of what did Dr. Atchison know at the time, and what did he do to treat Ms. Hamill during her visit? What did he do to try to determine what her actual condition was at the time? And so I think all of that, and again, I'm not pointing to any specific exhibit here, but I think the information in general that was presented, and looking at the C10 standard, I don't think the court can say absolutely as a matter of law that Dr. Atchison complied with the standard of care in his treatment of Ms. Hamill at the time, even given the information that he had. So for those reasons, the court finds that summary disposition under C10 would not be appropriate, and Mr. Hacklaw, the court will request that you prepare an order reflecting that.
Thank you, Your Honor.
All right, thank you. That moves to our next motion, and Mr. Hacklaw, you're free to address these however you want. I kind of looked at the motions regarding to preclude the household services and the earning capacity claims, kind of all, I don't know, they all seem to kind of dovetail together, but you're free to, or I don't know, is Ms. Shabbat going to handle these ones?
Yeah, she's much smarter than I am, Judge, so she's going to handle the remainder, I think the remainder of the motions. And I know there's a lot of overlap too with Munson's motion, so it may make sense in spots to combine, but let me defer that to somebody who's paid more attention to those motions.
Okay, so Ms. Shabbat, however you wanted to go forward with your motion, and then Mr. Busker, I'll give you an opportunity to jump in there as well.
Yes, I think, Judge, the overriding issue relates to the economic damage claims, and there's a few different facets to that argument. The first is obviously looking at the impact of Daher on the category of damages that are even allowable in a wrongful death case. And as co-defendant's brief points out, and ours does too, Daher sort of changes the analysis of all of this. And I think when these motions were first drafted, Daher was a pretty new opinion. I think there's been some further development of the law in that regard, and I think we all have a better understanding of what that ruling means for assessment of these damages in wrongful death cases. So the overriding, premise of Daher is if these damages are not enumerated specifically in the Wrongful Death Act, they are not recoverable. So, and then they go on to specifically say claims for loss of earning capacity, claims for lost wages, those are no longer recoverable. They go through an extensive analysis of the entire history of the wrongful death statute. They go back to, a 40-year-old opinion, and that Supreme Court opinion, Baker versus Slack, was then interpreted by the Denny decision to not stand for the proposition that these damages are not recoverable. And so what the Supreme Court did was essentially clean up any misunderstanding that there was and say, nope, we go back to Baker versus Slack. It's the law of the land. And not only that, but we reiterate that if these damages are not specifically enumerated in the wrongful death statute, they are not recoverable. So we're essentially, any earnings capacity damage claims are out. Any lost wage claims are out. And also what Daher did was specifically overrule by name the Thorne case. And the Thorne case was the case that had held that household services could be recoverable under the wrongful death statute. So under Daher, all of those damages are out because they're not specifically enumerated under the wrongful death statute. So then you get to the issue of what is recoverable. The only thing that is recoverable, other than a couple of things that are not at issue here, funeral, medical, burial expenses, those sorts of things, the only damages that are recoverable are loss of financial support. In order to recover for loss of financial support, there has to be some evidence that there was financial support. So that's where we diverge into a little bit more of a fact-based basis for exclusion of these damages. And I think that's one of the aspects where Mr. Busker's brief goes into a little bit greater detail for the court, but it essentially says either in Ms. Pasikowski's life care planning report and or her deposition testimony or Dr. Paranjapay's report and testimony, their whole premise was earning capacity damages. There really wasn't any evidence presented, nor is there any in the case, that there was financial support being provided that was being relied upon. Now, obviously, we have a minor child in the case, and so there would be sort of a theory or a presumption that his mother was providing some economic support to him. That's an independent issue of whether any of the testimony or reports of Ms. Pasikowski or Dr. Paranjapay should be admissible at trial. Those reports detail damages that are excluded under Daher. So if you go back to what the factual issues are in the case, the testimony in this case was that both Cassidy Hamill and her son were living with her parents. They periodically ate dinner with her parents. She was not paying rent. There's no evidence in my recollection of the testimony that there's any specific damages that were enumerated where there was evidence that supported a definitive loss of financial support. So this was a woman who never earned more than $19,000 in a given year. And as presented, she was living with her parents and they were providing support for her and her son. The testimony in the case was that they never had an expectation of support from her at any time in the future. The parents did not. So the only thing we're left with in terms of potential economic damages as it relates to these issues before the court is, was there any financial support being provided by Cassidy to her surviving son? That is not evidence that was addressed by Paranjapay's reporting or Pasikowski's reporting. And so I think the collective position of the defendants is all of the damages that are addressed in the Pasikowski and Paranjapay reports are now excluded under Daher. And to the extent that there is anything left, those reports don't address it. And there's very little evidence that there was any loss of support. So I think the defense motions point out that we're not seeking to exclude that category of damages, loss of support, because that is still recoverable even after Daher. What we're saying is these reports by these experts and these opinions by these experts are not the way to get there. There seems to be a suggestion in plaintiff's briefs that loss of earning capacity is the starting point for a determination of loss of financial support. And the defense would argue against that position. The earning capacity, there's no basis, there's no relevance to that evidence. It doesn't get in under Daher, and it would be grossly misleading to the jury for any of that evidence to get in because it's not relevant to any damages that are actually available. The only thing that can come in is actual evidence of a loss of financial support, and it has to be a specific pecuniary loss, and it has to be documented, definitive, all the same standards for evidence getting in front of a jury. So that's sort of the crux of the way I view the collective motions of the defense. I will defer to the other defendants to, clarify the points of their motions if that's if there's something different than what I've articulated.
Thank you. Mr. Busker?
Thank you, Your Honor. Just briefly, whether lost earning capacity is recoverable here is conceded here. On page 3 of plaintiff's brief, they say plaintiff concedes that the court in Daher held that damages for a decedent's lost earnings capacity are not recoverable under the Wrongful Death Act. So we're all on the same page there as the starting point. The question that I think is twofold. One is plaintiff does dispute whether household services remain recoverable post Daher. And then kind of the secondary argument after, we in our position is these claims should be dismissed. Then the secondary point is, do the reports and the testimony from Baranjabi and Pezikowski talking about earnings capacity and talking about household services in the way they do, does that still allowable as evidence, as the plaintiff argues, for the types of damages that are allowed? Loss of financial support, household services, in their argument. Regarding, I think it's very important here to distinguish that earnings capacity and how different of a thing it is than lost financial support. It's not just that one's the whole thing and one's a reduced set, right? You're looking at a completely different person. In the question of lost earnings capacity or future lost earnings, the question is how much money might this person have made throughout their life? Right. And that's what Paranjapi talks about. It was Paranjapi's report in Daher that was stricken, right? His report found you can't do that. It's the same person with the same type of report that we have in this case. And that's how you end up with these really big numbers that don't seem to make common sense, right? Where you have a person who was earning $14,000, $16,000, $19,000 in the years leading up to her death. And then under Paranjapi's report, she'd make $47,000 the next year. 10 years later, she'd be making 200 and something thousand. It's because they're not actually looking at what that person earned or where that money went. They're looking at national averages and potential earnings that she might have gotten. What the loss of support is it's not looking at that person who died. It's looking at the people who survived. What financial support were they receiving and could expect to continue receiving from the decedent? So the evidentiary question will be, and it's correct, we're not moving to dismiss that loss of claim for financial support. As we mentioned in our brief, there may be evidentiary arguments in the future regarding what type of claims have been supported or haven't been by the evidence. We're not doing that here. We agree for the purposes of this motion, a loss of financial support can still be brought, but it's a completely different question than the lost earnings capacity. It's how much financial support was her minor son receiving, and how much financial support would he expect to continue receiving? And that the evidence that would come in there would be, well, how much was she earning and how much of that money was going to her own use versus the use of her son? That's where we get into questions of, well, how much was she paying for rent or for childcare or for his clothing or whatever else? And that's why I feel like often these types of future economic damages, when we're talking about wages or earnings, they get conflated as just being a bigger piece or a smaller piece of the same thing. But what Daher does is it completely changes or reconfirms really who we're supposed to be looking at, whether we're looking at the person who died and all the money and benefits they may have received, or whether we're looking at who's left in the estate and what they may have received. Another way that that's easy to distinguish is if you were looking at a loss of support claim, it would be time bound. You know, she has this child who's 5 when she dies. Okay, he's expecting support for how many years, right? Whether you say until he's age 18 or 20 or something like that. And the economics reports for loss of support would be, here's the support you'd expect to receive during that time. They still have to prove it evidentiarily what that would be. Well, lost earnings capacity goes on for her entire life because it's not limited to money she's providing to somebody to support. It's what might she have earned. And so that's, I think, my biggest disagreement with where plaintiff comes in and tries to say, well, look, the earnings capacity testimony and reports from Parangipi and from Pezikowski speak to that. The jury gets all the information of the total bucket, and they can pick how much of that would go to the son. And I don't think that's supported by anything that the Daher court has done or how these issues are supposed to be addressed. Like counsel said, these motions were filed shortly after Daher came out. In the interim, since that's happened, that's why we submitted these supplemental briefs. As you can see, there are circuit court orders. Plaintiff's counsel attached one that we believe is wrongfully decided, right? That says no, Daher still allows some of these additional damages. We provided a couple other circuit court orders that follow Daher, we believe appropriately, and dismiss these types of claims. But I think far more telling are these legislative documents that we attached. Right. Within the last month, there was a House bill and a Senate bill and a House Financial Services Committee that were looking to amend the Wrongful Death Act. And the specific bolded language to be added in that list of things you can recover under the Wrongful Death Act was adding the language of damages for deceased lost earnings capacity and damages for loss of the deceased's household services. If the remaining language in Daher currently allows household services, it would be nonsense for the legislature seeking to amend the Wrongful Death Act to add household services to what's recoverable. Right now, with the language as it is, lost financial support does not include those types of claims, and it certainly doesn't include them in the way that's presented by plaintiffs' experts. Similar to the lost earnings capacity argument, those lost household services that are put up, again, are not tied to what was actually provided to her minor child. They're put out, again, for her entire life. Here is the economic value potential of household services a person like her could provide through age 80. That does not go to a lost financial support or the type of services that are recoverable under the Wrongful Death Act. So when we get down to it, I don't need to go through all the testimony from Parangipi and Pezikowski. I know I highlighted the key passages of their testimony in our motions and in our briefs. They were not pretending to be using her actual earnings or her actual household services provided as a basis for their testimony. They were very clear in their responses that they were unaware of what financial support she was actually providing, even what earnings she actually had. They were unaware of what household services she was actually providing, that they could, if there's some argument, well, that's part of a financial value that was lost. That was not the basis of their testimony. It was the exact type of damages that Daher found you cannot recover. I think legally, as far as what authorities were looking at, plaintiff relies very heavily on the Thorne case in their response. And it was overruled by name in Daher. Even the synopsis from the Supreme Court opinion, not the opinion itself, right at the top, it says, the Supreme Court held that damages for decedent's lost earnings capacity are not recoverable under the WDA, overruling Denny, Thorne, and Palomo. And then in the conclusion, there's a footnote that very specifically says Thorne is overruled. Right? That's the language. It's not something that's a mystery that we're supposed to interpret what Daher says and how it applies to Thorne. The case itself says Thorne's overruled. So that cannot be the basis for this claim for lost household services. And without Thorne, without the language from the WDA, plaintiff can't establish a basis for being able to bring those claims here in this case.
All right. Thank you, Mr. Dibb.
Your Honor, I'm not sure if my my motion got lost in the shuffle here because we also filed a motion on this same issue, but I don't want to repeat everything that's already been said. I just wanted to let the court know that we also filed this motion here.
Yeah, understood. Is there anything that you wanted to add to that?
I can just very simply, plaintiff references Red Risk Garden City at all. That was one of our cases. That case was actually distinguished from Daher. In that case, the decedent had provided household services to his surviving wife. That was all documented. It's factually different, and and that's all I have to say about that. We agree completely with everything that co-defense's co-counsel has said. They made the same arguments that I would make, probably a lot more clear though. So if you have any questions, I'd happily answer.
Okay, thank you. Mr. Deb?
Thank you, Your Honor. So let's put to rest any issue regarding Daher and loss of earning capacity. Yes, as was pointed out, we concede that Daher stands for the proposition that lost earning capacity is not recoverable in a wrongful death case. Everybody agrees to that. However, the Wrongful Death Act still permits damages for loss of financial support. I think we all agree to that. There hasn't been any question about that. And I would submit that the case law, including Daher, I might add, supports that the Wrongful Death Act permits recovery for loss of services, or loss of household services. And it's our position that the loss of financial support would, in fact, be based on earnings. So to the extent that whatever Cassidy's earnings were, her earning history, that it would be important as an evidentiary point to allow the jury to understand what level of income she was making so that she could provide this financial support to her parents, who are claimants under the Wrongful Death Act, and to her minor son. She was, there's no question that she was taking care of her minor son, and that she was contributing to the household services. Her and her son were living with her parents. And this loss of financial support is well-founded and not speculative. In fact, the evidence which defendants ignore and don't address, the family testified that to a number of various things that Cassidy would contribute by way of financial support, that she would frequently take them to dinner and buy dinner, that she took care of her child, that the parents, the grandparents, were not involved at all in taking care of this child. It was strictly Cassidy who took care of this of the child. There was testimony that Cassidy assisted with the household chores, such as laundry and cooking and things of that nature. She even helped her father with auto repairs. And she spent most, if not all of her money, according to the testimony of the family, on her son. She fed him, she bathed him, she provided all the necessities of life for him, purchased his clothes, and spent, according to the testimony, upwards of 16 hours a day when with her son when she was not working. She was either working or with her son. She also paid for the cell phone for her parents. So there is testimony that she was providing financial support, and this evidence of financial support and household services does not have to be proven with any level of mathematical certainty. We've submitted case law that that supports the proposition that that this evidence is sufficient if brought before a jury. And we do have expert testimony, which should not be ignored in this case. And even though they were deposed before Daher was decided, Ms. Pasikowski did calculate what the cost would be to hire a replacement for Ms. Cassidy in terms of caring for her child. And she calculated the number of hours in household services, 2.7 hours, the hours of primary child care of 2.3 hours, and secondary child care of 5.1 hours. And according to her calculations, it would cost on average $16.08 an hour, or $33,450 a year, to replace her in terms of the household or housekeeping services that she was providing, and another $30,370 a year to replace her for childcare at $14.60 an hour. Dr. Paranjapay's, and maybe they need to be redeposed post Daher, but Dr. Paranjapay's calculations put the loss of household services at the present cash value of $1,623,962. Both Dr. Paranjapay and Ms. Pasikowski are experts. They based their opinions on the specific facts of the case. Ms. Pasikowski reviewed Cassidy's employment history, her medical history, interviewed the parents, and Dr. Paranjapay also reviewed Pasikowski's reports and calculations, prepared his expert report, and based it on economic principles and economic literature that makes his opinions not speculative. So to that extent, we would respectfully submit, and by the way, there was a case which counsel indicated they disagree with, but there is a circuit court case. We attached two orders. One was simply an order denying the defendant's similar motion as what's being presented today. And the other case was an opinion that examined the issues that the court is being asked to rule on today, which again denied the defendant's motion. So for these reasons and those set forth in the brief, Your Honor, respectfully we request that this motion, and I think there are two motions combined in one here, that these motions be denied.
Thank you. Mr. Bott, anything you wanted to say in response?
Yes, Judge. Daher excludes household services. That's just all this commentary about Pasikowski's report and Paranjapay's report and what they included and how those are characterized. Loss of household services are not loss of financial support. They are not the same thing. Loss of household services were specifically excluded by Daher because it overruled Thorne. Thorne was the only authority for the Wrongful Death Act purportedly including loss of household services as an element of damages. Daher clarified all that and said, if it's not listed, you don't get it. Loss of financial support is the only thing listed. We can't morph loss of household services by attaching a dollar value to them and say, okay, now they're magically loss of financial support and they're recoverable. They're two distinct categories of damages, and Daher excludes one and allows the other. So we just flat out disagree with the characterization that any testimony from these experts about household services, regardless of how that was characterized, what they looked at, what they opined, that whole category of damages under Daher is out. So, and it's out for two reasons. It's out because the overriding principle of Daher is if it's not listed in the Wrongful Death Act, you don't get it. And then just to be even more clear, they go on to say, we're overruling Thorne. Daher is a Michigan Supreme Court decision that was unanimous. So yes, there may be some trial court opinions out there. You know, the defense, I have filed this motion in other cases. The number grows every time as far as the trial court opinions that we can attach. Obviously, plaintiff has found a couple that they can attach to. But the bottom line is we have to follow Michigan Supreme Court precedent. And under Michigan Supreme Court precedent, these damages are not allowable. Then just addressing again the factual argument as to what these experts looked at. There was no pretense, as Mr. Busker pointed out, there was no pretense that they were tying these damages to specific evaluation of this case and what support had been provided. There could in the future potentially be some documentation of purported loss of support damages. That is not what these experts relied on. It's not what they testified about. It's not what's in their reports. So those are the primary points that I wanted to make. This whole category of damages on household services, regardless of which expert said it and what they said, that's out under Daher. As far as the specifics, could they come up with some listed damages in theory that are evidence-based, loss of pecuniary support for this child that had been provided in the past and on that basis could be provided in the future? In theory, that could be presented, but it hasn't been presented to date, and it hasn't been presented in any admissible or organized way. So those are just the points that I would refute from plaintiff's argument.
Thank you. Mr. Busker, anything you wanted to add to that?
I agree with all of what Code Defense Counsel has said. I wanted to point out that Daher didn't change the law, right? It was a unanimous Supreme Court decision saying this is how it has always been. There have been a couple cases that have come up in the last 10 to 15 years that have moved away from what our precedent is, and we're setting the record straight, right? So they looked back at the Supreme Court decisions that have talked about these type of damages. They looked back at what the Wrongful Death Act actually says, and they said, no, we see a couple Court of Appeals decisions that have been expanding on this, that have been reading between the lines and adding to types of damages that are recoverable. And the Supreme Court said that's wrong. That's not how this works. That's not what's recoverable here. We're sticking with how it's always been, what the statute has always said. Here are the recoverable damages. So it's not like there's some big change in the law that resets everything that we need to do for litigation, what these experts have said or what they can rely upon. It was a unanimous Supreme Court decision saying this is still what the rule is. And these other couple cases, Thorne and Denny, that found otherwise, they're wrong. That's not how it works. Go back to what the language actually says is recoverable. None of those issues that are recoverable are what plaintiffs' experts have spoken to. And that's why we have this two-tiered, it's an MSD to dismiss these types of damages. And then there's a follow-up question afterwards. Well, if those types of damages are dismissed, are these reports still admissible to try and salvage into support for a loss of support claim? That can't be done. They're looking at the wrong question, the wrong type of damage, and an unrecoverable damage. And so that's why we're moving for summary disposition of these types of damages, and then separately moving to strike these experts and their testimony and their reports as not speaking to any of what's left as a recoverable damage. Thank you, Your Honor.
Your Honor, can I just add one quick thing that I failed to mention?
Let me make sure Mr. Frisch doesn't have anything he wants to add.
There you go. Sorry, my computer froze. No, I don't have anything to add.
Okay, thank you, Mr. Dibb.
I just wanted to add real quickly, and I apologize. Keep in mind that the Michigan standard jury instructions, which are promulgated by the Michigan Supreme Court, sorry about that, that the Michigan jury instructions promulgated by the Michigan Supreme Court do provide for loss of financial support and loss of services. So to that extent, I would suggest that the Supreme Court continues to recognize loss of services as recoverable under the Wrongful Death Act. That's all I wanted to add. Thank you.
Okay. On this issue, and I think it's reflected in the arguments of parties here today, it's my view that this is a matter that the court would be well advised to address in writing, given kind of the changes, or, well, to Mr. Busker's point, maybe not changes, but developments, I guess, in the case law. So on this issue, the court is going to issue a written opinion, and I will get that out to the parties as quickly as I can. Ms. Shabbat, I mean, is there, there's also a motion out there for earning capacity claims. Is there anything that you want to add on that motion that's different than what we've already addressed in terms of the household services?
No, Judge, I was essentially arguing all of them together.
Okay. Mr. Busker or Mr. Frisch, anything else on that particular issue?
No, I don't have anything else to add.
Okay. Did I miss any motions that we haven't addressed yet?
Your Honor, I do have what I termed as more of a housekeeping motion that wasn't responded to or opposed. That's a motion to dismiss the claims of ordinary negligence and claims against any parties other than the 5 doctors who are named.
Okay. Mr. Dibb?
Was there any, excuse me, and forgive my ignorance on this, was there a discussion with my associate about that?
We were trying to get a stipulation in place, weren't able to get it stipulated to, so then this was filed along with these other motions. There's an attached order. I'll see if I'll pull up the language of that order here. Our proposed order is that all remaining alleged claims or causes of action for ordinary negligence are dismissed with prejudice. Any remaining or alleged claims or causes of action regarding care or treatment provided by any individual other than the remaining individual defendants, including any, quote, unnamed staffs, healthcare providers, OBGYNs, family medicine physicians, whole list of other people that were identified in that way in the complaint, are dismissed with prejudice. And therefore, the only remaining claims are for professional negligence, medical malpractice by Drs. Eaton, Atchison, Leorden, Lagatuda, and Schubert.
Okay. I mean, I don't see any issue with respect to stipulating to dismissing the ordinary negligence claim and pursuing the claims only as to the remaining defendants. I mean, that seems rather axiomatic, doesn't it?
Yeah, absolutely. As the hospital, we're always concerned about claims against people that are identified but haven't been pursued. And so that's why
I just want to make it clear that there are claims of vicarious liability, respondeat superior, against the hospital. And I don't want those claims to be dismissed. But with respect to who the remaining defendants are, I have no problem. Who am I dismissing?
No parties are being dismissed, only claims.
Well, okay. So the claims.
I'm going to let, this is something I think council might want to have just off the record discussions about. I don't know that this needs to be something
okay.
Record. And Mr. Busker, if there isn't a stipulation as to what you're asking for, then I think that's something we could probably take up, but it doesn't sound like it would be real substantive. So.
Your Honor, I'd ask for a ruling on my motion. I had quite a few emails with plaintiff counsel's associate trying to get this stipulated to, and we couldn't get it done, which is why we filed the motion, attached the proposed order. They didn't file a response in opposition. So if possible, I'd just prefer to address the motion and ask that our proposed order be granted.
Well, I'd like an opportunity to see those emails that were exchanged and why there hasn't been a stipulation to date. And if they can't be agreed to, I'd like an opportunity, therefore, to answer the motion. But I'm confident that we can agree to the purpose of your motion. I'd like an opportunity to review whatever emails were exchanged. And if we cannot agree, then an opportunity to answer the motion. I don't think that's an unreasonable request.
Well, I mean, Mr. Busker, you filed a motion, right? So presumably
September.
everybody had a copy of it, an opportunity to respond already. It's January, so what I'm going to do, Mr. Busker, I guess, is that I'm going to hold off. I'll make a ruling on that motion part of my written ruling on the remaining motions. To the extent that the parties are able to agree, if you can circulate a stipulation in order, that will eliminate the need for me to address it. And, you know, I anticipate it's probably going to be, 14 to 30 days before I get the written opinion out. So parties will have an opportunity to discuss that. If there's no resolution, the court will rule on it. It doesn't sound like to me this is something that needs to be an issue, given where we're at in the case at this point. But well, that's how we'll go forward on that. Any other matters outstanding for today?
Your Honor, today was also set as a trial status conference. There's no further deadlines or dates currently set in the case, and we weren't sure what the court's plan was next for that.
So the way I'm going to address that will be by an order as part of my written opinion. The court will most likely, what I'll do is set this for a status conference following issuance of the written opinion on the remaining issues. That's going to give all counsel an opportunity, given the rulings today and that ruling, to confer with your clients, and then we'll all meet for a status conference. We'll take a look at things we're at. What everybody's positions are, and we can schedule from there so that parties can expect that to occur within the next 30 to 60 days.
Thank you, Your Honor.
Thank you, Judge.
Okay, thank you. That's all for today. Have a good weekend, everyone, and all parties are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Judge.